fear of Mr. Chaskalson is the beginning of wisdom. It has now become the new tactic that whenever a witness is scheduled to appear before the Madlanga Commission and learns that Advocate Chaskalson is the evidence leader, they suddenly fall ill and run to the hospital. Van Wyk did it, Julius Mkhwanazi did it, and Mr. Naku did it too. Today Suleiman Carrim did exactly the same thing. Mr. Chaskalson has officially become the Commission's whipmaster. The last time Brown Magotsi appeared, he went so far as to file a formal complaint demanding Chaskalson's removal as evidence leader before he would even agree to testify. What is it about this man that leaves all these criminals absolutely terrified to face him? Today, Suleiman Carrim's arrogant lawyers walked confidently into the Madlanga Commission, trying to teach Mr. Chaskalson how to do his job. But Chaskalson immediately activated and tore those arrogant lawyers apart until they practically begged to leave the room. Welcome to today's podcast. If you love the work Mr. Chaskalson is doing, please do us a huge favor, hit that like button, and share this video with everyone you know. Don't forget to subscribe and turn on the notification bell so you never miss an update. Type kudos Mr. Chaskalson in the comment section right now. Let's hail him for the incredible work he's doing. Jabulani, roll the clip.
The adverse inference point. I'm talking about the adverse inference in the specific instance of not participating in a voluntary medical examination. That's what I was addressing. What Chair is putting to me, I think, is something slightly different, which is like, and I've not been an acting judge yet, but when that happens, should it happen, obviously, Chair, what you're putting to me is the ordinary decision-making process that a judicial officer goes to in circumstances where you will weigh probability, credibility, admissibility, and so on. And if you draw an adverse inference at the end stage of your report writing in analyzing the evidence, that can't be objectionable. That's the ordinary rules of evidence as we understand it. So if at that stage you draw an adverse inference, for whatever reason you draw an adverse inference, I don't think in principle that there can be an objection to that exercise of inference drawing. I was addressing the adverse inference point about the prior step regarding the voluntary election. So, in direct answer to you, Chair, if I was the decision maker and it was argued in front of me that an adverse inference must be drawn, that Mr. Karim is a naughty person, so to speak, because he didn't participate in the voluntary disclosure.
That's what I'm trying to get out of the equation. There is an inference is being drawn and becomes adverse because of one saying, because of his failure to testify, we are drawing an adverse inference. That's what I'm trying to say. Let's get that out of the equation and just look at the evidence that's before the commission and then decide what to make of it, just as evidence that's before the commission. Of course, it will be a fact that certain allegations have not been answered, and one takes it no higher than that. So it's at that level that I'm engaging.
Then we're at Eden.
Not an adverse inference based on the failure to testify, in the sense that maybe he was being naughty. Why would he not testify? So I'm engaging you at the level of the reality is that here is evidence to which there is no answer, period.
But then we're at Eden, because that's what I was trying to draw the distinction on. If Chair puts it to me in that way, and that's the disaggregation that I was, with respect, motivating, you're not elevating the non-participation in the voluntary examination process to say, that's the evidence that you're naughty, I'm drawing the adverse inference. I can accept that. But if it's the second one, which is that it's unanswered allegations and therefore I'm drawing inferences because of the failure to answer, that's the ordinary laws of evidence.
To get to that, what you call an adverse inference, to get to that, I think we would have to first make findings as to Mr. Karim's condition. Otherwise, it's just difficult, I think. I don't know what Mr. Chaskalson
Agreed. And because you'd have to consider potentially credibility or the, as I was saying, credibility, probability, veracity of the version. You'd have to engage with all of that. All I was simply saying about it depends on where that comes in. If it's the first step medical examination, that's where I may have a problem. But if it's the second step, which is what Chair is putting to me, unanswered allegations and what flows from unanswered allegations, to me, that's the ordinary principles of evidence. That can't be objected to. Unless, of course, there's a question of Audi or whatever
All right, you may continue.
Thank you, Chair. But the second point I was going to make in respect of the medical examination and less intrusive means is that, and I say this with due respect, because we're not in Uniform Rule 36 territory, there is no comparable direct access to a witness as far as I understand it. My understanding, and you'll know, for example, in the litigation involving President Zuma and the competency of his medical certificate that he used to excuse himself from another commission, if I'm not mistaken, which went originally in front of Judge Pillay, who might have acted with Judge in the Con Court, but is from the KZN division. There, the contention was not when the commission, I don't want to call it the Zondo Commission, but you know which commission I'm referring to. When that commission had issues with the medical certificate and the medical fitness of the witness or otherwise, they had to impugn the medical certificate as the first step and potentially the person who authored the medical certificate, because that's the evidence upon which the witness relies to say, I should be excused from giving the evidence. So why I mention that is because what our learned friends say is that because they've come up against this medical certificate as they have, they must go directly to the witness and subject him to a medical exam from someone other than the doctor of his choosing. Whereas what they could do is they could engage the medical practitioner themselves. If they wanted to, they could have, we could have, I say we in the sense of if Chair gives directives to that effect. And again, I'm not committing myself to this version, I'm just theoretically testing the proposal put in front of you, is that we could have an in-camera hearing, because obviously we'd need to test the fullness of that confidential medical evidence, so it can't be for open public consumption. But then that's what we do, and the commission might choose to cross-examine the particular medical professionals. They might wish to lead the evidence of their own medical examiner, who, might give an expert view of the expert view that we've tendered. We might want to cross-examine their own expert. So that what I'm saying is that I'm not immune to the Commission's concerns about concluding the evidence of Mr. Karim. But we've played open cards with the Commission to the extent that we can, by providing all the correspondence, by providing 4 medical reports, giving all the details of all the treating doctors, and before we must leapfrog to subjecting a person to a compelled medical examination, or potentially a voluntary one like Chair says, we must think about the balancing exercise of constitutional rights. And if there is less intrusive means that can nonetheless enable the Commission to do its job, then we would argue from the perspective of proportionality and reasonableness and balance, then that's an available mechanism. May I just make my last main submission? But before I do that, Chair, I don't know if you want to...
Just to say what Chair poses.
Yes.
I think to say says sounds stronger to me. I think there's a nuance there.
Yes, no, then I withdraw every use of the word says, and I rather use the word posits. If the transcriber can edit the transcription, that's perfectly
No, they don't need to. It's part of the engagement.
Yes. No, I accept that. And I'm grateful for the clarification, Chair, because also what I'm doing is I'm trying to be helpful to you, Chair, and the commissioners by engaging the debate and giving as cogent an answer as I can, hamstrung by the fact that I can't commit my client to a version in the absence of knowing the Commission's position and without instructions. So that's the rock in the hard place. The rock on my right and the hard place on my left, perhaps, that I'm stuck between in trying to engage you, Chair. So that's as far as I'm trying to take it. My third and last main submission, if I may, Chair, is that I've heard what my learned friend said about the recommendation for prosecution. Chair already identified mens rea as the requisite element and how that would need to be investigated, and then the prosecution would flow. All we'd point out is we've also addressed this in our letter of yesterday, which I take you got probably very late last night, if not early this morning. And we did say that if that's going to be the case, that the Commission, for whatever reason, chooses to make a motivation to the Commission that a recommendation be made that our client is prosecuted, that we get an opportunity to address the Commission before an adverse decision is potentially made against him, because that's Audi Rights 101. So Chair, that's to respond to what my learned friend said regarding everything else other than the 15th of July date. On the 15th of July date, we are in your hands and we will do as directed. Thank you, Chair. I'm indebted, and I know I've taken a long time, but thank you.
Thank you, Mr. Premier. Mr. Chaskalson?
Chair, I don't want to respond now because this is a debate, if it is ever going to arise, for another day. But I do want to place on record that we don't accept many of these submissions. And in particular, the one worrying thing that we see is what the medical reports disclose is that Mr. Karim has not been hospitalized continuously since April. He tends to get hospitalized just as his appearances before this commission are scheduled, and that is worrying. And it's particularly worrying in the context of a situation where very basic, quite aside from his appearances, there are very basic requests for some documents to be furnished, like financial statements. It doesn't take much to issue an instruction for financial statements of a company to be made available to this commission if you're not in hospital. And what we see is a simple refusal to comply with these notices, coupled with a pattern of, as an appearance date appears, suddenly Mr. Karim needs hospitalization. Now, it may be perfectly true. It may be that by coincidence, or possibly not by coincidence, his medical condition compounded by the stress of an imminent appearance requires his hospitalization. It is, I'm not saying it's not true, but it is worrying. And what is particularly worrying is that very, very basic requests for information have been outstanding since Mr. Karim last testified, at a time when he was certainly fit enough to testify, fit enough to travel outside of the country, and we still wait for the documents that he promised us when he gave evidence. I don't want to say any more now. I'm hoping this never becomes an issue that we need to take further.
Every single time Karim is supposed to show up and answer for this stuff, he suddenly gets rushed to the hospital. It's happened repeatedly since April, and he still hasn't handed over the bank statements they asked for. His lawyers are trying so hard to back him up, claiming he's seriously ill, but Mr. Chaskalson isn't having it. He essentially told them, look, either you let an independent doctor examine you to prove you're actually too sick to talk, or we are going to charge you with criminal obstruction, and ask the Commission to make findings based on the evidence we already have. But this is not where it started. Let me play you a clip from his last appearance. The last time Suleiman Carrim actually stood before this commission, he tried to lie to cover up his criminal links with Kat Madlanga. He even claimed he was scammed out of 10 million rand by Madlanga, trying to play the victim so that Justice Madlanga would pity him. But instead, they completely crushed him with forensic evidence. Jabulani, roll the clip.
Mr. Karim, you'll remember that yesterday I asked you, and I think Commissioner Baloyi also asked you questions along the same lines. I asked you as to why Mr. Madlanga had not paid directly to Mr. Maumela. And I think you didn't really have an explanation for that. Am I correct?
No, I did, counsel.
You did. All right. What was
I
the
did,
explanation?
Commissioner.
I'm sorry.
No,
I'm sorry.
I said he insisted. And I said to him on numerous occasions, you can do it yourself. You can pay this money.
Yes.
Why do you want me to pay this money? He said, look, you need to help me. You need to pay this money. I'm under pressure. I need to pay him this money. And that was the explanation that he gave me.
That's not really an explanation. That's just an insistence that you must do it instead of him. So it doesn't really explain why you and not him. So I guess that's why I was saying, and you didn't really have an explanation.
Yes.
Yes. Now, it seems to me that this gets complicated in the sense that Mr. Maumela, I'll paraphrase, of course, I will not use the exact words that you used. You said something like, Mr. Maumela said to you, this man had to pay him, and that you must pay him after you've been paid. Am I correct? Is my paraphrase correct?
No, I'm saying the arrangement was between them. And once Mr. Matlala,
I'm talking about, am I correct that there was communication between you and Mr. Maumela in relation to the payment? Am I
yes, but
correct?
before that, him and Mr. Matlala were discussing the payment.
Yeah. But now I'm talking about...
Me and Mr. Maumela, yes.
Yes, yes. And as I say, I mean, I took cryptic notes, but what I captured was you said something like this man being Mr. Matlala, must pay must pay Mr. Maumela. And also that once you have received payment from Mr. Matlala, you must then pay Mr. Maumela. Am I correct?
Correct.
Yes. So I'm saying this, in a sense, gets complicated in addition to the questions I asked yesterday. I'm wondering, in my mind, Mr. Maumela already knows that he's going to be paid out of monies that have been paid to you. And I'm wondering, why is he not saying to Mr. Matlala, pay me? And did you ask, why must it be this secateurs? Why must it, instead of the direct payment, let me, as Mr. Karim, just get my money, and that's it. I have nothing to do with you. Get your money directly from Mr. Matlala. Do you have any idea why it had to be secateurs?
Like I said, Commissioner, I kept on saying to them.
I'm addressing between you and Mr. Maumela now.
It had to go. I agree that rightfully Mr. Matlala had to pay him, but like I said, they put me under pressure for me to have paid him. And I think I didn't refer to a document yesterday. And if I can just take you to this document on the messages.
Yes.
So he wanted me to pay him, and at the same time, if we can just go to the messages. When he called me to make this payment, he then called me and said, look, I've got more invoices in. I think those invoices.
You are talking Mr. Matlala.
Yeah, Mr. Matlala.
Yes.
So in order for him to make me or to force me to pay, he said to me, there's another 13 million rand going to be paid. So please, if you can pay this, and I'll see you good on the next payment. Because at that point, I was still asking, why don't you pay it directly? You can't pay it directly. He said, no, you must pay him. Please help me pay him.
It would have been much, much easier and quicker for Mr. Matlala to pay directly to Mr. Maumela. I'm sure you would agree.
Yes, I agree. But
Yes, yes. And did you ask Mr. Maumela why the payment had to be secateurs?
according to him, he said that was the instructions from Mr. Matlala that the payment will come via me.
But did you ask Mr. Maumela?
Yes, I asked him, why don't you ask Mr. Matlala to pay you?
To pay you
Yes, to
directly.
pay you. Why is he paying me? He said, no, Mr. Matlala said, you're going to make the payment, so that's why I'm calling you. Please, when you receive this money, make my payment.
But that doesn't answer the question, but why me instead of directly? Did you ask that?
I've asked him. Like I've said, I've asked Mr. Maumela, Mr.
Yeah, you see, thing is, being told that Mr. Matlala said he will pay you and you will pay me doesn't answer the question, but why is the payment not direct? Do you get what I mean?
Yes,
Did you ask why is the payment not
I
done?
did ask. I just didn't get a response from Mr. Matlala was just insistent. He would just be insistent. He would say, please, you just have to do this. He would not even give a reason. And I asked him, you can make this payment directly. You don't need me to pay him. Why must I pay him? And he gave Mr. Maumela the same story and said, just call Karim and tell Karim to make the payment once he
So
gets it.
you basically have no explanation from Mr. Matlala. You also have no explanation from Mr. Maumela. Did you not become suspicious of all this?
No, Mr. Matlala's explanation, like I said, he either owed, I can't remember correctly, either owed or loaned, something to that effect.
Earlier I asked you, and what you said was not really an explanation, and I said to you in so many words when we commenced with this debate, I said, but that was not an explanation.
Yes, he didn't give me an explanation,
So,
Commissioner.
yeah, so my question then is, you have no explanation from Mr. Matlala, you have no explanation from Mr. Maumela. Did you not become suspicious about this secretar's mode of payment and why it had to be so?
Yes, I did, but like I said, on Mr. Matlala's instructions, there was more money to come. So I didn't want to upset him so that I don't get money on the next payment.
So you say you did have a suspicion. What was that suspicion?
No, the suspicion was that why would he not pay directly? Why
What
would he
was-
want to pay me?
What was the nature of the suspicion that
No,
you had?
I just-
What did you suspect?
No, I just suspected between the two of them, why were they using me? They could have just dealt directly. And then Mr. Matlala then says to me, look, there's another payment coming in of 13 million. I'll see you good there, so please just do this for me, and when the next payment comes in, I'll sort you out.
And then despite that suspicion, you just went ahead and paid as requested by Mr. Matlala.
Correct.
Thank you. Thank you. Thank you.
You were referring to the chats. Are you referring to the chats of the Morgan sorted payment, which are on page 7?
No. Can we just go back to your question? We were busy with, we were busy with the chats.
No, I'm just following up on the question the chair's asked you at this stage and your answer to the chair. So you said at the start of your answer you wanted to refer to the chats, and you talked about a call that you had with Mr. Matlala, and if I understood your evidence correctly, that was the call where Mr. Matlala said, just do this and now there's more money coming, I'll pay you out of the next payment.
Yes, I was going back to the issues of, I think, was it the chats between Morgan and between Mr. Maumela and Mr. Matlala.
Which chat? So there was the chat in relation to invoicing at the end of January. There was the chat that happened to be on the same day that Mr. Matlala met General Tlele at Mr. Maumela's house in Zimbabwe. Which of those chats were you referring to?
Now, I wanted to go back to where Mr. Matlala then sends me a payment screenshot on the 7th of March.
Look at page 6. Is that the screenshot you're looking for? The one that shows the payments that are going to reflect on the 4th?
No, I was going to the one of the 7th of March on page 8.
Yes.
Where he mentioned to me that these payments are coming, and then he then sends me the screenshot of those payments coming